Hold on. So you're saying, so if your child calls you and they're being abused and you take matters into your own hands, you get in the car, you drive over to your ex's house, you barge into the door, and you start assaulting or fighting your ex's new partner.
If you do that, as soon as you go into that house unwelcome and have the intent to commit a crime, that is a burglary. And it's a burglary of a dwelling. And here in Florida, that is a second-degree felony punishable by as much as 15 years prison. Forget touching, assaulting, or battering. If you're going in there with the intent to do that, you've now committed a second-degree felony burglary. If you take it a step further, you go in there, by the time you get there, there's nothing going on. The child is not being abused. The child's in another room, and you just go in there. You're pissed off because, your child said, "Hey, mom's new boyfriend spanked, slapped me." So when you get there, there's no longer an imminent threat. So you're not defending yourself. You're not defending somebody else at that moment because the threat is no longer there. The time has ended. So now you're in there. You break into the house. You push down the door, and you do commit an assault or battery. It goes from a second-degree felony to a felony punishable by life.
All rise.
I just want to be able to see my daughter.
Take a real man to be.
So you're just living off of his child.
We've gone over so many of these cases.
Order in the court.
Today I'm talking to Attorney David. Attorney David is a criminal attorney and he practices in the state of Florida and also Washington, D.C. for federal cases. And today's conversation is specifically about people that are dealing with false allegations in family court that has the potential to go to criminal court, and more specifically, we're talking about domestic violence, we're talking about child abuse, and we're talking about fraud. Mr. David, I wanted to start with this question. This is something that when I was, again, going through my divorce, and I got to the point where the allegations was just getting too serious, and I hired a criminal attorney, excuse me. The issue that I was having with the criminal attorney that I hired, it was trust. So I wanted to start with this question. So if I was, for example, to bring you my case, let's say I'm facing domestic abuse allegations, which are completely false, and I bring you this case, but first I want to be able to trust that you can handle my case. So if I bring you this question, I said, okay, Mr. David, why should I hire you to represent me in this case?
Well, first, let me thank you. I really appreciate you having me on here. And this is a very, very important topic. It's often overlooked because most times in the criminal world, it's a misdemeanor. And a lot of people think they can navigate those waters by themselves because it's not a felony. So I appreciate it. And this is also, as far as my opinion is concerned, the one area criminal charge or civil allegations for injunction or in the divorce, the biggest abuse of the judicial system, of the justice system, whether it's criminal or civil, there's just a tremendous amount of abuse of this. And so I'm really glad that I have this opportunity to speak with you and your audience about this. I think the most important thing when you're interviewing lawyers is to try and meet with them face to face if you can, because you get a lot more of a feel for who you're going to be working with, who's going to be helping you navigate through the case if you're face to face, as opposed to just being a voice on the phone. So I think that's important. Now, of course, sometimes it's not just that easy to go ahead and do that, and you do the best you can. But if you can be face to face with your lawyer, if you're face to face with me, you're going to get a real good feel for who I am and how I operate. So what I try to do is I don't try to, this is exactly what I do is I speak the truth. It's just that simple. And what I tell people is this: I might not tell you what you want to hear, but I'm going to tell you what you should want to hear, because not everybody wants to hear the truth. They want to hear what they want to hear. So I'm very direct about that. I'll be very clear about my opinion about something and the guidance that I give. And I think people appreciate that. So there's number one. Number two, it's very clear when I represent you that you're never going to have an issue with communication. You should be able to communicate with your attorney. So as you're looking for a lawyer, you're going to have questions. Okay. When you have the questions, you should be able to pick up the phone and be able to, if not get them answered right then and there, at least schedule a time where you can have that phone call or have that email access. And one of the things that I do, since you asked if you came into my office, is if you're my client, you're going to get my cell phone number. Okay. So if you need an answer in a pinch, you shoot me a text, and I'm going to either pick up the phone and call you when I see it, or if I can't call you because I'm either in court or I'm in the middle of something that I can't step away from, I'm going to shoot you a text back. But you're going to have that communication as soon as humanly possible with me. So, and number three, we're going to be talking about your case. So not only am I going to listen to everything that you have to say, okay, I'm going to hope, because we're interviewing each other when you come into my office, because I might not want to take your case. Okay. So I'm going to hope that you're also listening to everything that I'm saying. And as long as we have that mutual respect for one another, and we're listening and we're absorbing everything that each other has to say, we're going to be a good fit. And you need to, whether it's me or anybody else, this is another thing I tell everybody. When you're hiring a lawyer, it's a big decision, okay? Because this is the person that's going to be part of your life for, maybe the next few years, okay? So you want to make sure that person, that you get a good enough feel for that person, whether it's me or somebody else, that this is the person that I want to go into battle with, that I want to be there to protect me. And so you have to get that feel for that lawyer. And you're going to get that when you're face to face. You're going to get that, of course, I like to believe that you're going to get that with me. But if we have this conversation and you don't get that feeling with me, then I'm not the right choice for you. Okay.
Right.
You need to get that feeling about the lawyer, that this is the person that's going to just going to do right by you.
Yeah. Yeah, it's. I was actually going to ask that, and you covered that question. One of the issue that at least some of the people that follow me, many of them, they always complain about communication when it comes to the attorney. So they will hire you, they pay you a retainer. The next thing you know, when they're trying to reach you, it's damn near impossible.
Let me follow up with that, though.
Go ahead. Yes, sir.
Because it's not only important for you, for your comfort level. Okay, at least I can speak to my lawyer and get some answers. But it's also important for the preparation of the case. For example, I have a case coming up. I have depositions on a case coming up next week. So what am I going to do? I called up my client. I said, we need to, I had my office schedule a phone call. We're going to go over certain things so I am more prepared for the deposition. Because one thing for sure is I wasn't there when these allegations would have occurred. Okay. And I don't know the person on the other side as well as you do. So how am I going to get this information? I'm going to ask you. Okay. So you can reach out to me anytime, but of course I'm going to want to reach out to you anytime I have new information for you or I need information from you. That's the way you take care of this and have a more complete defense on your case.
Right. Yeah, absolutely. And to anyone that just joined us recently, I'm talking to Attorney David. Attorney David is a criminal attorney, and he practices in the state of Florida and also Washington, D.C. And today's conversation is about domestic violence, child abuse, and fraud as it relates to the family court that has the potential to, go from family court or civil court rather to criminal court. All right, Mr. David, I wanted to jump straight to it. At what point should you start looking to hire a criminal attorney?
Immediately. I mean, that's the one word answer, immediately. And they say that only because the longer you wait, the more memories fade, witnesses disappear, they're less available, and evidence disappears. So you want to try to secure your defense right away. So I always tell people in answering that question, no ifs, ands, and buts about it. But you also want to prepare for your defense even quicker than that. You want to prepare for that defense as it's happening, as this incident is happening. And I know we're going to get into that, and I don't want to get ahead of the game. But there are things that you can do to help yourself before you call your lawyer the next morning. Okay, and it's all about documenting. You want to make sure that You all know your partners. Okay, you know
Right.
if they've got a temper, you know if they don't tell the truth all the time, you know if they massage the truth, uh, whatever. You know who you're with. Okay, and if you know you're with somebody that tends to do one of those things, then you need to start protecting yourself long before an incident happens. How do you do that? Okay. Well, if you can lawfully do it, record it. Okay. And it doesn't mean holding the phone up in their face, because that's going to agitate them. But if you can hit the record button while the phone is in your hand without shoving it in their face, that's one thing. If you can hit the record button on a tape recorder, whatever it can do, these are things that you can do before you even have to worry about calling me. Okay, because once the police are involved in most jurisdictions, when they show up, somebody is going to jail. Okay, that's just what the policy is. The policy is there to. It's not that they want to arrest somebody that doesn't need to be arrested, but if there's a domestic call, they want to err on the side of caution. Okay, and they want to separate the two people. And in many jurisdictions, that means arrest. Okay, and sure, they're going to do a little bit of an investigation, but you're dealing with your rookie police officers that don't have a tremendous amount of training. They don't have detective training or anything along that line. They're responding to a 911 call. They go there and they're going to talk to the caller first in most cases. In most cases, the person that calls is the one that is not going to jail. And in most cases, the person that's going to jail is going to be the man, because in most cases, these calls come from women, because men, more often than not, don't make a call because they're pushed or they're shoved or they're hit or they're kicked. They want to get past it and preserve the relationship. That doesn't mean that men are not committing domestic violence. It just means men are less likely to make those phone calls or document these things than women are.
Women, right?
So
Right.
these text chains, any videos, anything that you've experienced, because there's a lot of people that argue over the internet, over the instant messaging or texting, and they will say things such as, if you do this, I'm going to call the police, and what they would be, I'll tell the police this. Well, that's evidence. So those are the types of things that if anything like that comes out, you want to hit that screenshot, take a screenshot of that right away, because if there's a way that can disappear, it will. And so you got to protect yourself from the onset, and then call a lawyer as soon as possible.
Right. It's funny you say that. A video that was sent to me last week of a gentleman, he was arguing with the mother of his child, and she started just throwing things at him. And one of the only good thing that he did, in my opinion, he started recording the entire incident. So police were called, and when the police I actually have it on my YouTube channel. When the police got there, he was the first person that they arrested until he was able to show them the footage, just like you said. He was able to show them the footage of what exactly happened, and they ended up arresting the girlfriend as opposed to him.
And now I can show you the recording. Because now her son about to say I've been putting my hands on him and stuff, but I haven't.
Isaiah?
Yeah, he gonna say that because she gonna tell him to say it. So I was recording too, because she broke my phone. Knocked my phone out my hand. See? When I was recording, because I just don't want to go to jail. I don't want...
You can record it, because guess what? It's my phone. My phone, and I'll show them in my settings that's my phone. It says,
What happened to the top of the
He
door?
took my phone. Yup, he took my phone.
Top of the door been broke.
He got
From
my
the last time, remember when you was there and all that thing happened? It still never got fixed.
So that's actually a good point there. So always record. So if you can keep what you say, text messages, emails, videos are usually some of the best ones, right? You would say just video recording are the best ones.
Yeah, if you can do so, that would be great. You want to preserve that evidence. But you don't always have that access, or it's just not as easy to shoot a video as it might be to just audio record it. But whatever you can do, and like I said, a lot happens over the text messaging and this instant messaging. A lot of information. If you see anything in there and you know that you're married to somebody that has that ability to be a little creative, then you're going to want to save those conversations.
Yeah. It's actually sad to even think about, to think about going down this road with someone that, you once loved or you once had a good relationship with. So when you say a text message, are you talking about text messages that leads to the incident, or like she's texting you, I'm gonna call the police, or I will do this to you, things like that? So you just preserve those, or what are you referring to when you say
I
text
would do
message?
all of it, but because I've had cases, I've been doing this for almost 30 years now, and I always think I've seen it all, but then there's another day, and then you really see it all. But I've had cases where I get text messages from my clients, screenshots, where they say, I'll give me this, or I'm gonna tell the police that you hit me, or that you abuse the children, or I'm gonna keep the kids away from you unless you come back to me. Things along that line, anything along that line. Those are good things because that shows motive from the accuser, first of all, and it also takes away from their credibility. I had literally just today, and I was reading this, and I couldn't believe what I read. I represent somebody on a domestic violence case. They hired me a couple of days ago, and then I show up to work today, and my receptionist hands me a piece of paper and said, this person dropped this off. And I read it, and it's a declination of prosecution from the alleged victim. And it's not just saying, I don't want to prosecute. It's saying, I was mad, I made the whole thing up, and I know I shouldn't have done it, but sometimes, and it just got in great detail. I'm thinking to myself, I would have never written this because now she's subject to prosecution, but she wrote it on her own, brought it to my office. I never saw her. And now I have this declination. So I sent it over to the prosecutor. I have no duty to her. If she handed that to me when I was here, I would have probably said, you might want to talk to a lawyer before you do that. And, we've got other lawyers around here that I would have had her meet with. But she flat out admitted she lied. And that's rare. Usually they just want to back out. Usually what they want is and I say the accusers, whether it's a man or a woman, they want separation. They don't always want somebody to go to jail, or, or sometimes it's used as a power move. But then they don't want the, they don't want they want the case to go away because, okay, we've had our argument. This person went to jail. Now I want to get back with them. So it's very common that it's just a tool that is used. But yeah, it happens every day.
Wow. I wanted to go back to something that you say that was very interesting. So you say text messages. So text messages leading up to the incident. So anything that says, well, I'm keeping the kids away from you, or if you don't do X, Y, Z, I won't do this or do that. So when the fight now breaks, God forbid, and the police are called, that can be used as, like you said, motive to, I guess, to protect. Okay, that makes sense. Because most of us, when we think about these text messages, we don't look at it from a criminal perspective. We just look at it from a civil thing that you can bring before the judge. But when these criminal allegations are now raised against you, it's very hard to defend yourself because you just don't know. You know what I mean? Like, you don't know how to use those evidence in
courts, in both criminal and civil courts, because the judge or jury are there to listen to the evidence. And here's another thing. Evidence and truth, are not the same thing always. Okay? Evidence is what the jury or the judge hears, what's in court. So if somebody goes in a court and lies, that's still evidence, right? So it's important that you do your best to make sure, especially if you haven't done anything wrong, that evidence and truth are as close to the same as possible. So that's why anytime there's anything along that line, whether it's for an injunction, whether it's in a divorce proceeding, whether it's in criminal court, you want the trier of fact to have something to hang their hat on to show that that person that's testifying against you does not have credibility, How you do that? Well, when it's just you and that other person, and it's the he said, she said, it's not always the easiest thing, and it depends on the burden of proof. In criminal court, it might not fly, but in front of a judge, in injunction with the lower burden of proof, it might be enough.
Right.
But then you throw in something where, hey, isn't it true that this is your phone number? And you know, because you have it right in front of them. Yes. And isn't it true that you text Mustafa, well, you know, all the time, right? And isn't it true on such and such a day at such and such a time you said in a text message to Mustafa, or rather, do you remember what you said to him on such and such a date, such and such a time? No, I don't remember. If I showed you a copy of that text, would that refresh your memory? Well, yes, it would. And then you show that person their text. Okay, does that refresh your memory? Okay, you watch them in their chair start squirming down a little bit and or looking away or getting angry. And then you say, isn't it true on that date and time you said, if you don't do this for me, I'm going to call the police and tell them you hit me? Yes, case closed.
There you go. Right. Wow. See, I know you make it sound simple, but that's a lot of work. If you are trying to represent yourself, that's a lot of work to do.
I've been doing it for a very long time. What it's not a lot of work to do, it's not a lot of work to preserve that. Okay. And you want to preserve it, and you hope for the benefit of your relationship that you never, ever, ever need it. But I can show you on my cell phone, and it's not domestic. It was in a contractual situation where I just, at one point, I felt things going south. I have voicemails. I don't want to lie. I want to get it exact. I have voicemails on my phone.
Wow.
From December 26, 2012. Okay.
Wow.
So if there's anything that I think that I need to save just in case, I save it. And I hope I've never used it. And I don't think I ever will, but just in case,
right?
You know, that's me protecting myself, and that's universal for whatever type of legal situation you have. If you think that there's something in there that you know that you want to hang on to, you really should make an effort to do so. That's the easy part.
Yeah, no, that's true. You know, I was recently I had to file a contempt case, literally about a month ago, and I represented myself, just putting the evidence together to stand before the judge. It was a lot of work. You know, when I first hired my divorce attorney, she charged me $5,000 for a retainer, and then the price just went up from there. So when you have never done the work, you would think that attorneys are high, you know, their prices are very high, until you stand before the judge trying to present a case with that one, you know, and it clicks to her. You know what? This is why I need an attorney. You know, just like you simplified earlier, but it's a lot of work. It's really a lot of work when you're trying to do it by yourself. You know,
well, you're talking about the finances. Do you mind if I just chime in on that issue?
Yeah, go ahead.
As it relates to the finances, there's an old saying: "You get what you pay for." Okay,
right.
And of course, it's not always right, but it generally is. And you know, you're paying more for a more experienced lawyer. You can find lawyers that are inexperienced, and if they're inexperienced and in turn inexpensive. And again, going back to where we started this, if you have confidence when you meet with that lawyer that this is your lawyer, then you know this is who you want. Then that's who you get, regardless of the price, even if they're on the low end of the finances. But on the other hand, if you find somebody that you like and it's a little bit more expensive, and you've done your homework on that lawyer, which you should always do. Word of mouth is great. Look on the internet. The reviews, there's a lot of fake reviews out there. So I mean,
absolutely. I was just about to say that. Well, yeah, go ahead.
If you're doing your homework on a lawyer and they have like 500 reviews and they've only been a lawyer for a few years, it's not authentic. Okay.
Right.
So, you know, but look at the reviews and ask around. Asking around is so important. But when you find that person, you know, most of the higher price lawyers are higher price for a reason. Okay. And most often it's because they're good. Okay. There are certain cases where I know I'm going to be the highest price guy in town because I know there's very few people that can do what I can do on those particular cases. Then you go to a different type of case, and I know there's a lot of people that can do what I do, and my price is a little bit more competitive because it's there's a lot of lawyers that are very qualified to do that particular type of case. So I'm a lot more expensive on things that are more specialized for a reason, because I've been doing this for almost 30 years. I've built the knowledge and the relationships, and with if it's criminal, with not only the prosecutors but with the police, with the judges, so all of that, and that really does play a role when you have a lawyer that has a good reputation with the other side and with the judges. It really does. What you say is taken as what it is, as opposed to there being any reluctancy. So if you can afford a lawyer, even if it stings a little bit, that you're more comfortable with, then you spend that little extra for that level of comfort. I have plenty of people that have come into me, want to hire me, and then they hire somebody else because they are less expensive. And then they come back to me a few months later and say, hey, can you take over this case? Sure, if the situation is something where I still feel that, I can help them, and it's not the last second right before a trial, sure, I'll jump in on that case. But I feel bad because they've already spent money on this lawyer. So, it's really something to be considered. And I'm not telling you to go out there and find the most expensive lawyer, or that every expensive lawyer is good. I'm not saying that at all. Okay. But what I'm saying is, if you have done your homework and you have looked into the background, asked around, and met the lawyer and got a good feel for that lawyer, then I would do whatever it took to get that lawyer.
Right. I'm with you. Yeah, I learned it the hard way, to be honest with you. I learned it the hard way. And I would never advise anybody to ever take on a criminal case on your own. Find a way to get the money, get you a good attorney, for a better chance. So I wanted to ask you, so someone who is facing domestic violence, but they have no evidence whatsoever, no text messages, no phone calls, nothing, So this is something that basically caught them by surprise, and they are now in jail, waiting to face the judge. Do you take on it? Well, how do you represent someone like that? Let me ask that question first.
So I know what you're saying, but I'm going to correct what you're saying.
Okay, please.
Because you're not going to get arrested if there's no evidence. Okay.
Okay.
What you're really saying is, if it's somebody just says, hey, he did this to me. Okay. So the evidence is the testimony. Okay. Because if you go back a couple of generations, one generation, there was no texting. Right. 2 generations ago, there was no videotape. And yet people were still going to jail. And that's because of testimonial evidence. So I think that's really what you were saying. If it's only what they say, okay, now it becomes a he said, she said. And it really depends. The strategy depends on, it changes from jurisdiction to jurisdiction. For example, here in Florida, we're allowed to take depositions in criminal cases, which is fantastic. In most jurisdictions, that's not the case. When people from other states hear that I'm allowed to do depositions, Massachusetts, for example, you can't take depositions. Here we can for felonies, and if it's a misdemeanor accusation, with the permission from the court, we can take depositions. So that's one thing that I would want to do. Other things that I would do is I would look into. You're telling me that you were not even in the same place at the same time. This never happened. So now let's try to reconstruct the scene. Okay, tell me where you were at this time. Okay. Oh, I was at Fridays. Okay. Do you have a receipt that you were having dinner at Fridays or Chili's or whatever? You have a receipt for that? Give me that. Okay. What we're doing now is we're trying to build that alibi. Tell me about your relationship. Is there anything in the relationship that you think that, and dig deep and ask around to anybody that knows you, knows your partner, and dig in and see if there's anything out there at all. But when there's nothing, it's just one person's word versus the other person's word. The government in a criminal case or the plaintiff in a civil case is going to, or petitioner in an injunction is going to simply say, this is what happened. So we're going to try to find something more. So it is not just a he said, she said anymore. It's she said this, but hey, look what we have. Now let's take it a step further. We still don't have anything. It's just, look, I don't have any receipts. We were home that day. We were sitting down. We were watching a movie. I don't remember. I don't know why he or she would make this up. And I don't have anything to say it didn't happen. Well, kind of we do. Are there any injuries to this person? Well, if it's just a simple he said, she said, any photographs or any visible injuries, that's evidence. And the fact that there is none there, that's also a lack of evidence. And going into the criminal arena, a lack of evidence is a way that a jury or a judge, if you do a bench trial, can get to reasonable doubt, which is a not guilty verdict. Okay. So I have had cases like that where it's a literally he said, she said, and we've been successful on that, especially in the criminal arena when it's he said, she said, and you're dealing with a jury. A jury's going to want more in most circumstances. The problem is when you get into the civil arena with an injunction, it doesn't always go the way you want to because the burden of proof is lower. And again, sometimes the judges are thinking, well, you know what, I'm not positive one way or the other, and both sides seem reasonable, but in an abundance of caution, we're gonna do that. You can't do anything about that, but you just got to dig deep and see what you can come up with. Sometimes character witnesses can come into play. I've actually looked into in cases. One of the things that I would do, Mustafa, is you called me on this question. I'd say, tell me about her prior boyfriend. Okay. Tell me why they broke up. And the one before that, why they broke up. And you'd be shocked. Now we call the ex, and the ex said she did the exact same thing to me.
Wow.
Okay. Yeah. So you just never know where you're going to find something, but you know, if you don't look, you're not going to find anything. So you always look. You got to look outside the box. You got to think outside the box to build a defense.
So what if someone that have a prior criminal records? Does that make the case harder to prove in court, or how does that work?
Well, it depends. And I'm going to speak for Florida courts. Okay. Now in Florida courts, the prior criminal history is admissible in very limited circumstances. First of all, if I'm representing you and you have a prior criminal history, they're only allowed to bring that up during the evidentiary portion of the trial if you get on the stand, first of all, or if it's an element for an enhancement. In other words, if this is your second and it's an enhanceable offense and they need to prove the first. But what I would do is I would stipulate to that so the jury doesn't need to hear it. Other than that, it's either a crime of dishonesty or a prior felony. And if it's not one of those two, then they can't bring it up. And again, it's if you're on the stand or if it's an essential element of the crime that you're accused of. Where it becomes more difficult is not so much in the trial aspect, it's in the if we're going to negotiate, it certainly plays a role there. And if we're trying to get the case dropped, the more of these allegations that somebody has in the past, whether they were dropped or not, leads the prosecutors to believe, rightfully or wrongfully, that, oh, you must have done this because you've been accused of this in the past or convicted of it in the past. That's where it really becomes more difficult. In a circumstance where it's a he said, she said, and we need, our client to get up on the stand to present our side, well, then obviously that's going to be a factor for us, myself and my client, to take into consideration as to whether or not we want them to get on the stand, because not the exact priors, will come out, but a number will come out because the permissible questions are as follows. Have you ever been convicted of a felony or a crime involving dishonesty? And if the answer is yes, then you say yes. And then the next question is how many times? Okay. And that's the extent of exploring into the priors for most circumstances. There are exceptions. For example, it's called Williams rule, which is similar fact evidence. That can come in if they are able to lay the predicate and procedurally do it properly. But for the most part, it's those two questions.
Okay. All right. Can we talk a little bit more about?
Not allowed to ask those questions.
Go ahead. I'm sorry.
They're not allowed to ask those questions, or procedurally, they should not ask those questions if the person does not have any priors.
Okay. Oh, so you said they don't ask the questions, or can you say that last part again?
Yeah. So let's say, and again, I'm just going to use you as an example here. If you get on the stand and you have no priors, you better believe the prosecutor is not going to ask you that question. Okay. They would never ask you that question because they don't want you to say, no, I have no prior criminal history.
Right.
They can't ask about prior arrests unless they get prior consent from the court in a hearing before the trial.
Okay. So they have to ask the court for permission before they can even bring it up.
And that's that's not for convictions. That's for similar fact evidence. In other words, in the example I give on similar fact evidence, not relating to domestic cases, but just to give you an idea, let's say a bunch of banks are robbed by a guy wearing a Richard Nixon mask, and they never catch the guy. That happens 10 times. And then the 11th time it happens, they catch a guy wearing Richard Nixon. And they have him now for that one charge, but they want to convict him for the first 10. They can use that one charge as similar fact evidence to try and convict him in this case. And in order to do that similar fact evidence, or for it to be admissible, there are certain procedures that have to be followed, and there needs to be a ruling prior to court. But as far as prior convictions, those can be used if the witness gets up on the stand, if the accused gets up on the stand and is going to testify. Absolutely, the state can use that against the accused if it's a felony or a crime involving the state.
Mr. David, the more you explain these things, it explains why you need an experienced attorney. Because I know you are trying to simplify it, but going through something like this, handling it by yourself, it's a lot of work. I don't know anybody that don't have any prior any prior of any type of law practice. You can't do these things. You know what I mean? You can't do these things. So a simple, at least to me, a simple domestic violence case that now has the potential to get to criminal court can become something so major, if you're trying to handle it by yourself. I wanted to ask this question.
Let me follow up with that, because you brought up a great issue here, where a civil case becomes potentially a criminal case. Now, if I get hired on a case and it's an injunction against domestic violence, or repeat violence, and the allegation, of course, is a criminal act. He or she hit me. I need protection from that person. Now you go into that injunction by yourself, and the person, the accuser, the petitioner, says, hey, he did this all to me. And now you want to get up there and say, well, here's what really happened. Problem is, that's all recorded and that's all under oath. Now, if you say anything that you really shouldn't say, that can be used as evidence against you in the criminal case.
Oh, wow.
So you got to be really, really careful on the civil side how you present the case, because even if the case is going to go criminal because they've called the police, now what you're doing is potentially creating more evidence against yourself.
Right.
Yeah. If you gave a statement to the police and now you're giving a statement to the court, and they're not perfectly aligned, you're going to get impeached on that. So it's there's a lot that goes into how a court proceeding is handled. And there are certain cases where you can go in there and navigate it yourself. I tell people, I told somebody yesterday, they hired me on a case. I said, it's a ticket. And I don't like doing tickets, but this was for a friend of a friend. So I said, I'm going to tell you exactly what you need to do. I'll tell you right now. I'll even give you a script if you want. I'll type it up and I'll email it to you. Because I didn't think they needed to make that investment in me. Okay.
Right.
So there were some very few and far between where you can go forward. They ended up hiring me anyway because they were a little nervous. But there were very few times where you should be comfortable going into court without a lawyer. But it is the overwhelming minority of circumstances. But you should always, whether you're going to have a lawyer or not with you when you go to court, you should always consult with a lawyer beforehand before you make that decision.
Right. Absolutely. So I wanted to define domestic violence if we can. So I don't know if there is if there is one domestic violence case more severe than the other. I know, of course, if you're talking about murder or things like that, that's a lot more, but some simple domestic violence. I wanted to just touch on that just a little bit to see so people will get a better understanding when we're talking about domestic violence. What are we referring to exactly? So let's say, for example, my ex calls the police and say, you know what, I hate her. That's domestic violence, right? Let's say just an argument where it's now getting loud between us. She calls the police. Is that considered to be a domestic violence as well?
Just getting loud?
Just getting loud. Just argument getting loud. Nobody's getting hit. Nobody's nothing like that. So that's not considered to be domestic violence. Okay, so it's usually when you...
That is not.
Go ahead.
That's not domestic violence. See, I knew this question was coming. And of course, doing this as long as I've been doing it, I have a very strong grasp on domestic violence, but I didn't want to cheat your audience out of the exact definition. So I printed it up for you. It's not terribly long. I'll give you the highlights really quickly. Let me put on my glasses. All right. So this is the Florida rule here, domestic violence definition. Any assault, aggravated assault, battery, aggravated battery, sexual assault, sexual battery, stalking, and other charges, or any criminal offense resulting in physical injury or death of one family or household member by another family or household member. Now, this is important. What is a family or household member? Okay, because what if it's you're divorced, or what if it's an ex and you no longer live together? That doesn't get you off the hook automatically. Okay, because family or household member means a spouse, former spouse, a person related by blood or marriage, persons who are presently residing together as if a family, or who have resided together in the past as if a family, and persons who are parents of children in common, regardless of whether or not they have been married. So, I mean, it could be a roommate. It could be an ex-roommate. It doesn't even have to be, a couple. And so it goes on and on. But that's the definition of domestic violence, and I pulled that from the Florida statutes and all that. But let's talk about, I guess, you asked about arguing. Can arguing be domestic battery? Well, it's no, because a battery is the intentional touching. You have to have contact with somebody for it to be a crime of battery. But there's always an assault. Now, of course, an assault, the definition I gave you is not the criminal statute. It's within the marriage statutes, the domestics. But the definition of family member is the same. So if you are to commit an assault, for example, I don't know, you hold up a bat to somebody and, right up to them and you say, just as if you're going to hit them, but you stop, or you swing and you miss. That's an assault, but that's not a domestic battery. So they are treated differently in criminal court, but in injunction land and in divorces, maybe not so much.
Oh, wow. So even if you just, that threat alone, it's criminal, basically.
Well, it can be. If it's a conditional threat, like if you don't have if you don't have this house cleaned by tomorrow, I'm gonna shoot you, or whatever. I'm gonna beat the crap out of you. That's a conditional threat. That's not a crime. Okay. Certainly, you shouldn't be saying it. But, but here in Florida, that is not a crime because it's conditional. It's not. There's no immediate threat of it happening. Okay. Or if you're on the phone and you say, I'm gonna come over there and I'm gonna do this, it's not an immediate threat. The threat has to be imminent. Okay. You can say it in order for it to be a crime. But I wouldn't say those words anyway. I mean, I know this.
Right. We don't want that. Right. So for stalking, go ahead. I'm sorry.
No. Let's get into stalking.
All right. So no, I mean, you're right. If we don't want anybody listening to us, go ahead and and saying those words to anybody. We don't want that. So for
and that being said, in the heat of the moment, which is when we all say these things, I'm sorry, I'm down to these cough drops here.
No, that's all right. It's all right.
In the heat of the moment, when people are most likely to say something or do something that they really should, that's really the time you need to just walk away. Okay, it's not about winning or losing the argument. It's about walking away. That's your win, because if it keeps on escalating, the impulses may take over, and you may say something or do something. You may be angry at somebody and just grab them by the shoulder and say, "Please stop." Well, you just committed a battery. You put your hands on their shoulders, and they didn't want your hands on their shoulders.
Right.
So it's always best to take a step back. Distance yourself from the situation. It doesn't mean, could mean just going to the next room or whatever, or going for a walk. You don't ever want to make a threat. You don't ever want to say something that's gonna come back and bite you later on. So if it's getting used against you take that breather, and then if you need to finish the conversation, then you try to come back and finish that conversation in a calm manner if you can. If you can't, then you just need to stay away. Just stay away until all the tension has dissolved.
That's a good point. That's a good point. Keep your hands to yourself, basically. Right. That's a very good point. All right. So for stalking, and again, you can correct me if I'm wrong with this. So stalking is basically any type of contact, unwanted contact, right? Or there is a specific definition to that. And I'm trying to see how does that becomes criminal. Let's say someone who is basically always outside your door, and you tell them that you don't want them here. You give them that first warning, but they keep repeating and doing the exact same thing. So when you call the police, how does that translate to criminal?
Okay. Well, you did say the key word there, and that's repeated, because just showing up at somebody's house unwanted one time is not going to be considered stalking. It needs to be repeated conduct, and it doesn't need to be the same conduct over and over again. If you show up at their house after they told you not to come by, there's one. Okay. And then you call them up and they don't answer, and you keep on calling. It's repeated and repeated. You're texting, you're calling, you're showing up at their work. And it doesn't have to be all of this. It just needs to be repeated. It can be as little as 2. It typically is more than 2, but it could be as little as 2. But it needs to be for a purpose that's not legitimate. Okay. So for example, you and I were roommates, and it's my place, and I kick you out, and I tell you, don't ever come back here. I don't want you back here. You leave, but then you realize that you left some of your stuff at my house, and you want that, and you reach out to me repeatedly. Hey, I want to. When can I swing by and pick up my stuff? And I just never respond, and you keep on doing it and keep on doing it. And if I call and say, hey, I don't want this guy contacting me. Well, you have a legitimate reason to contact me, because you're not doing it to harass me. You're doing it because I have, I don't know, you left your watch at the house or something along that line. So if it's a legitimate reason, then it doesn't fall within that category of stalking. You may have to explain it away later on. So you may not beat the ride, but you'll beat the rap, they say.
So this is a question that came earlier. So this person is representing themselves, and the other party have an attorney, but the attorney is not getting in contact with the person that's presenting themselves, and the person that's presenting themselves keeps on contacting that attorney, Is that stalking or not?
No, because you have a contractual relationship. So that's not stalking. That's holding them to their side of the contract. And I hate to say it, there's something that they can do about it. Even if the lawyer's not returning the calls, you pick up the phone, you call the local bar association, and you can file a complaint.
Oh, so they can file a complaint but that's not their attorney though. I don't know if you understand the question I'm asking. So that's not their attorney. Can they file a complaint against the opposing attorney for not contacting them back?
Oh, if they do, I understand. So again, maybe I just missed the question. If somebody's representing themselves, but they want to talk to the other lawyer.
Right.
Well, I can tell you as an attorney, I have great pause in communicating with the other side. Okay. I do, but I'm very, very careful about it. And I always try to be very limited in that communication. I would rather that communication be in court. So I don't ignore those calls. I take those calls. I take a step above and I advise them that, understand I'm the opposing side here. And I don't want you to say or do anything that you shouldn't be without the advice. And I always advise them, you may want to consult with an attorney beforehand. But no, there is a way to have that communication with somebody who's pro se, somebody who's representing themselves. But I can tell you, it goes a lot smoother when you have a lawyer. But if you don't have a lawyer, it's not uncommon where we're going to try to set a hearing or a mediation. And it's always also better if everything is in writing. That way, there's none of the shenanigans or misrepresentations or misunderstandings, because we collectively as a society have this bad habit of remembering what we want to remember rather than exactly what was said or the total of what was said, to cherry pick the things that we like. So it's always better to have a way to have everything memorialized. For example, again, like we're doing right now, this is recording. So you can do the same thing in that sort of circumstance.
Yeah, because the email that he sent me, he actually sent me some of the email that he was sending to the opposing party. He's trying to, I guess, get them to have a conversation with them before he file, because he's trying to file a contempt as well. So he's trying to find a way that they can prevent the case from going before a judge or coming to some type of resolution, but the other party, it's not responding at all.
Well, there are in every state, there are rules of professional conduct. Okay. And those rules are what guide us as lawyers, how we are to act in an ethical manner. So the best thing I can tell your viewer, your listener, is to take a look at those rules of professional conduct. And there will be a section on communication with people that represent themselves. Take a look at that. And if they are not following the rules, or if you believe they're not following the rules, you can, I'm a big believer in, if you're going to send communication and you want to make sure they receive it, send it certified return receipt, make that, $5 investment in that. If you're still not satisfied that you get any response, and put a deadline on it, then absolutely. You can report them to the bar, or you can request a hearing before the court. Going against a lawyer in court, you're at a tremendous disadvantage. So the more organized you are, the better. And for those in your audience that choose to or have to represent themselves, there are they are held to the same rules and standards that the lawyers have, which means you need to follow them. And when a judge tells you to stop, you need to stop. When the judge makes a ruling, that's the ruling. Be prepared. You can't go in there and just say, here's everything I want the judge to hear. There's a format to it. There's a procedure, and you need to know those procedures. Right. And of course, that's going back to what we said earlier. It's always better to have a lawyer, but I understand not everybody can or chooses to.
Yeah. Which I think when it comes to criminal cases, that's the silliest thing that you can do, trying to represent yourself in a criminal case.
They say Person who represents themselves as a fool for a client. I would never represent myself.
Right.
Ever.
Absolutely. Yeah. Civil cases are a little different, but when it comes to criminal, I think that's one of those things where just find a way to get the money, get you the best attorney that you can possibly find to go stand before a judge. That's absolutely right. All right, so we can jump to child abuse. And again, this is something that I haven't dealt with this personally, but I had a few people when I ran the poll into my group that dealt with this where false allegations of child abuse were raised against them, and they were now afraid that it can, get into, criminal court. So I wanted to bring you that. So when it comes to child abuse, are there a specific child abuse claim that can be raised against you that would jump straight from the civil court all the way to the criminal court?
Well, again, being a Florida-based lawyer, I'm speaking in terms of Florida, but I do believe it's pretty universal or pretty nationwide. And any child abuse can be criminal. Any child neglect can be criminal. That doesn't mean every one is. You can make a claim, again, in court in a divorce or custody proceeding, or a claim in an injunction. I've had cases where I had a case where there was a claim of child abuse, and there was an injunction filed against them. Fortunately, there was no criminal claim, but sure enough, if there were enough to this, there could have been a criminal claim. But absolutely, every single incident or accusation of child abuse can fall within both categories.
Wow. Wow. So, and then that, I'm guessing that's also the same, I guess the same procedure when it comes to keeping evidence, keep text messages, phone calls, videos, anything that can prove that what they are saying, it's not true.
I'm not going to put myself in everybody else's shoes. Everybody has their own style of parenting. Right. And while corporal punishment is permissible, it's not permissible to the point where you're going to leave a mark or you're going to cause an injury. There's no question that you're going to have some problems in the courts, whether criminal or whether it be civil, to deal with if you're going to leave a mark or cause an injury. Okay, so I don't want to sit here and tell people how to punish their kids, because again, everybody's situation is different, and I respect everybody's opinion as to what they believe is the best way to punish their children. But as long as they understand there is a limit to that, you don't want to cause any bruising, you don't want to have any cuts, and you don't want to have anything broken or anything along that line. So when I say corporal punishment, there is certainly a limit to it. But again, when somebody calls the police, even if you are within the limits, the police may act first and let you clean it up later in the courts. And that's unfortunate, but probable cause is all that's needed to make an arrest. And probable cause is a very low standard. It simply means loosely means that there's some credible evidence that you committed the crime. And that credible evidence could be in the form of somebody saying, I saw him do this to that child. And, and then all of a sudden, depending on how experienced or skilled a police officer is, that may be enough to put somebody behind bars. If not, it may be just for a night. But regardless, it now is an issue where it shouldn't be.
Right. And so when they put you in jail, now you got to worry about getting a bail, seeing a judge. Yeah, it just becomes a big old problem. Okay, so one of the questions that was asked when I ran this poll again is that, so what if your ex-spouse is now in a new relationship and the new partner is now punishing your children? How do you handle that?
Well, what I would do is say go to court and get a court order for it. I think that's the best thing to do. What you don't want to do is what your instincts are telling you to do. And if another man is over there spanking your kids, to go over there and take care of business. Okay, don't do that. All right, because now you're creating, I know that your instinct is I'm doing right by my kids, but you're not doing right by your kids if you're stuck behind bars. And now you've given your ex some additional ammunition to maybe alter the
custody, right?
The custody battle, the parental plan, and so you don't want to do that. Obviously, if it's a safety issue, you do what you need to do. Within limits. You don't need to go over there with a gun or anything along that line. But if it's not a safety issue, you just don't want this other person disciplining your child, then, of course, the first thing is to establish those rules with your ex. And if those rules are established but not honored, then you need the court to step in and enforce it. And then if that doesn't work, well, now you have contempt issues where that person is not following the court rules, and they can be held in contempt, and in theory can be sent to jail for violating a court order or for potentially, a child abuse type of charge. So you want to do things, and I hate to say it, but the slow way, okay? Unless it's an emergency situation. And if it's an emergency situation, you need to go over there and protect your child. I'm dialing 911 before I go over there, because I want there to be hey, this guy I just got a call from my child, and my ex's new partner is beating on him or her. I'm heading over there. Please get the police over there. There's the address. Okay, now you're doing it properly, even in that emergency situation. Call 911, okay? Let them know what's going on. They will tell you, don't do anything, which is fine. But by the time you get over there, hopefully the police are over there too.
Mm-hmm.
Okay?
Right.
You want to protect, you want to protect your kids, and I can't sit here and tell your audience they shouldn't protect their kids, but there's a way to do it. Because let me take it a step further. Let's say you do it the way your instinct tells you to do it. How are you going to protect your kids when you're in the jail?
Yeah.
How are you going to protect your kids when you have a no contact order? You're not. So you may have that very short term victory. Okay, I've stopped this right this second. I beat up this guy or whatever, but you're going to jail, and you're going to have a strike against you in that custody battle. So it's you may think you're winning, but you're not. And in most cases, and there are of course exceptions, but in most cases, you're not doing anything productive. You're just taking a step back. And another thing I like to call something like this baiting. Okay, you're being baited to do something wrong, whether it's with your significant other, or whether it's through the children. That the children may be inadvertently being used as bait to try to tick you off to gain leverage in a civil case.
That's a very good point. That's a very, very good point. And another thing too, if you go there, for example, and then you and the other guy started fighting, that can become a criminal case, right? Where they can file charges against you. And
for sure. And especially if it's not your house now, you've got
trespassing.
No, it's much bigger than that.
Wow.
It's a burglary with an assault or battery, which is a first-degree felony that you can serve the rest of your life in prison for.
Wow.
So if you go over there and you're going over there with the intent of, kicking somebody's butt because you don't like how they treated your kid, but they're not treating your kid like that at that moment, you walk in there unwelcome and you assault them or batter them, that's a first-degree felony here in Florida.
I turned it. Let's say that one more time. I want to make sure that I capture that properly. Hold on. So you're saying, if your child calls you and they're being abused, that's what it tells you over the phone, and you take matters into your own hands. You get in the car, you drive over to your ex's house, you barge into the door, and you start assaulting or fighting your ex's new partner. Can you explain that again, please?
Sure. If you do that, first of all, when you go into there, as soon as you go into that house unwelcome and have the intent to commit a crime, that is a burglary, and it's a burglary of a dwelling. And here in Florida, that is a second-degree felony punishable by as much as 15 years prison. Forget touching, assaulting, or battering. If you're going in there with the intent to do that, You've now committed a second-degree felony burglary. Now, the truth be told, in most cases, that's not where it's going to end up, but it could. Okay. Now, if you take it a step further, you go in there and, by the time you get there, there's nothing going on. The child is not being abused. The child's in another room and you just go in there, you're pissed off because, your child said, hey, mom's new boyfriend, spanked me or slapped me in the face or whatever. That's now done. Okay. That's not going to be happening while the kid's on the phone with you. That's now done. So when you get there, there's no longer an imminent threat. So you're not defending yourself. You're not defending somebody else at that moment because the threat is no longer there. The time has ended. So now you're in there. You break into the house. You push down the door and go in, or you just open the door, but you're not allowed to, with the intent to commit a crime. There's your burglary, the crime being an assault or battery. Then you do commit an assault or battery. It goes from a second-degree felony to a felony punishable by life. Now, Again, it's not something that they would likely end up that way. Here, we have those cases all the time, and they end up being something significantly less. And, depending on the circumstances, it's not uncommon where it gets significantly reduced or even dropped, but it doesn't always happen, so you can't count on it. What you need to understand is that is a felony punishable by up to life in prison, burglary of a dwelling with an assault or battery.
Oh, wow.
Mm-hmm.
I think you just had everybody door drop.
Yeah.
So
that's why you call the police.
Wow.
Have them do the dirty work for you.
Right.
Mm-hmm.
Oh, wow.
Wow. So you just created another conversation where we go back live again with the group. Now, this is something that, because I always tell them, no matter what, always control your emotions. Don't do the first thing that comes to your mind. And me personally, I'm so quick to call the police. I don't even hesitate. Where they live now, the police, they know me by name. And every time, especially when I feel like something is about to lead to, where I don't want it to go, I'll dial 911 and let them know. And I always have my camera. And I always tell my followers the exact same thing. Always find a way to protect yourself. Always protect yourself. But that's a very, very good point that you just made. So I wanted to close on child abuse. Can you go back to what you were saying earlier? So the police can arrest you just on the probable cause, right? Sure. So can you explain that just a little bit so we'll understand when you say probable cause, what do you mean exactly?
Yeah. So in order for you to be arrested, there doesn't need to be enough evidence to convict you. Okay. There just needs to be some credible evidence that you may have committed this crime. And that evidence can be in the form of somebody saying that you did it. Okay. And if there's no reason to doubt them, then guess what? You're going to get arrested. Now, that doesn't mean you're going to lose the case, but you're going to spend, at least a few hours in jail. Probable cause is a very low standard, and that's all it takes to make an arrest. Okay. Now, the dilemma that a lot of people have in these situations, and we'll go on one of these he said, she said situations, because I'm a big advocate for exercising your Fifth Amendment rights. So, for example, if somebody were to call the police on me and say that I beat them, okay, and I am probably, unless I have good evidence to say that it didn't happen, I'm probably going to eat it, and I'm going to say, take me. But, I'm not going to, I want to talk to a lawyer, okay? Other people may tell you, other lawyers may tell you, no, get your side out there. And that's not necessarily bad advice. Every lawyer, you talk to 10 different lawyers with the same circumstance, they're going to give you all a different opinion. But for me, when you put that story out there, again, and we discussed this a little bit earlier, every time you tell that story, there's going to be some minor differences to it. Okay. And if that story is not perfect every single time, you're now creating, well, first of all, when you tell that story, you're locked in. Okay. That's it. When you tell something else, now you're going to get impeached on it. So I'm a big believer in, if I'm going to tell my story, I'm going to get it right the first time. Okay. But a lot of people will disagree with me. and they'll say, well, why would you go to jail? Maybe if you tell your side of the story, you won't get arrested. Okay. And I'm talking specifically in a domestic situation right now. And there, again, there's plenty of logic to that. But here in this jurisdiction, if there's a domestic call, somebody's going to jail. And the probable cause very simply may be that somebody said you did something.
Oh, wow. Oh, wow. Okay, let me ask you this, because it sounds like how many kids do you have, Mr. David, if I can ask that?
I have 2 kids.
2 children. Because okay, it sounds like you speaking from a father's perspective. All right, so can we talk about that just a little bit? Is that all right?
You want to talk about my family? Love it. Let's go.
I hope it's not too personal.
No.
Okay, good.
And again, there is no one mold for everybody. I had the good luck to start building this practice before my children were born. All right, so I knew not much beforehand. I had a couple of years of a head start before my first child was born, and with the way I built my practice, because for when it comes to work, my clients are number one, but when it comes to home, that's job number one. Okay, so I have always been of that belief of I know how much I want to work. Okay, and that changed over time, but most recently, I would say about 2 years ago, it changed significantly. Up until the time when my youngest went to college and I had a child at home, up until 2 years ago, I didn't miss anything. Okay. So if there was a game, I would be there. If there was an event, I would be there. If there was just, hey, Dad, can we hang out? The answer is yes. How did I do that without neglecting my clients? Well, it's very simple. It comes down to being efficient when I'm in the office and my caseload. All right. I will never have a caseload that takes up more time than I have for work. Okay. There are very few weekends where I have to come in because of my caseload. I try to keep it relatively low. And because I try to be very productive, between the hours of 9 to 5. So that's how I was up until the time my youngest left the house to go to college. It worked out very well for me. I never neglected a client. And I always had that frame of mind that if I have cases, if my caseload becomes too big, where I can't have that other part of my life, or if I'm having to sacrifice that part of my life, then I need to hire somebody else to help me to make sure that I can get back to where I need to be. But that's all. My business practice is quality over quantity. And so I don't want to be so overwhelmed where work is everything to me. Now, again, I said that changed 2 years ago. So now I don't have the kids at home most of the time. So when they're not at home, I'm taking on a bigger caseload now because I have that extra time. I don't have to worry about, catching my kids' basketball games or cross-country meets or their plays or whatever it is that they are interested in. And I can be there for the picture taking before the events. So I don't have that anymore. But when I had that, I made sure that I kept my workload in a manageable way, that my clients were getting absolutely everything they were paying for and then some, without neglecting the other. And it worked out very well for me, meaning that when the kids were younger, that family time was more important than me making more money.
Right.
All right. So, can I ask what your kids do now?
Sure. My daughter is a junior in college. She just came home yesterday.
Oh, wow. Okay.
And actually, at the beginning, before we started recording, she popped her head on this podcast. That's my daughter, and I fear what's about to happen when she turns 21 in a few months. But she goes to college out in Arizona. And she's studying business management and finance. And she just told me the other day that she wants to start studying to take the law school entrance exam, the LSAT.
That's nice. Nice.
My son is graduated from Florida State last year, and he's got Monday. He finishes his last exam of his first semester in law school. So this may be Bigney and Bigney, in a few years, maybe not. Whatever he wants to do, it's up to him. But that's my kids. That's where they're at now.
Right. That's beautiful. See, I asked that question because, and this is why I wanted to have this conversation with you, because you understand as a father, and again, when we go back to these child abuse allegations, and I brought that question because you are able to relate to that. At some point, you were disciplining your kids. Again, I don't know how it happened, but you had to discipline them enough to be able to get to where they are right now. So to have someone who see you disciplining your child and then call the police and make it seem like you are doing something crazy to them, and now you have this case that you have to beat. You see what I'm saying? So hiring someone like you, to me, is more of, I guess, the best choice than to find someone that don't have children, or it's not in the life of their children, that can't really understand what's really happening. You know what I mean? Like, what don't know. I mean, they don't understand the case. They don't understand you as a father to be able to really stand before a judge and help the judge understand, either what happened or how to clear your name. You know what I mean? But the point that you made, again, because I want people to really understand when you say just a probable cause. If a police was called and somebody say, I saw him doing X, Y, Z to his kids, and now you get locked up. So you have to either get a bail for you to get out of jail, wait for a judge, and then stand before a judge. Before you even clear your name, you have to explain to the judge what happened, right?
So what I'm giving you, the example I gave you about, he said that's a bit extreme, okay? Because there's going to be an investigation of some sort, but you're relying on an investigation most oftentimes being done by an experienced police officer. So they're not really going to know how to do things in the best way to get to the bottom of things. But sometimes that's like if they come over to my child and they say to my child, hey, did your dad do this? And I say, don't talk to my child. Okay. They may just have to rely on what this other person said, or they may call the Department of Children and Family. And now all of a sudden we're dealing with a dependency case potentially, where they're deciding whether or not there needs to be some sort of intervention where I need, because of this, maybe I need to go into some sort of parenting class or something based on, again, allegations. And the problem is, again, you're dealing with people that see things that maybe didn't see the whole thing, or maybe it's their perception was inaccurate, or they saw something that, with an obstructed view, and they automatically drew a conclusion, and all of a sudden you have these issues. So I don't want it to sound like that's all it takes, but in theory, that's all it could take. Okay. And I've absolutely had people arrested based on just what one person says. And in domestic situations, it's very common. I know we're on to child issues now, but they will get Department of Children and Family involved, and it becomes a big mess.
Mm-hmm. And so that translates from civil to now criminal if there are any type of marking on the child?
Well, it even without marking, there's that possibility of a crime. But if you're using that corporal punishment, obviously, to spank your child, or whatever, you want to make sure that you don't do it in a way that's going to cause damage to the child, and any sort of marking is going to be considered some sort of damage, and an overzealous prosecutor or police officer or witness is going to turn something that really is a bit innocent into or justified into something that is going to be considered criminal. So those are the types of things that unfortunately that you have to deal with, and you see it a lot, maybe in the airports or at the parks or something along that line, where you see one child become unruly, and the parent, they just why are you acting this way here, and they just want to spank that child right there, and then they just but a lot of times the child knows, I can get away with it here because they don't want to do anything here. I got a funny story for you, because I actually did spank my child one time when he was young, and it was in hindsight a very funny thing to me and to my wife, and turns out to my son at the time. He was probably like 5 or 6 years old, and he was just being unruly, which was very unusual. My children are far from perfect, but they were overwhelmingly good kids. But the timeouts weren't working, so I said, "That's it. You're getting a spanking." So I put him over my knee, and he is crying and crying, and I just didn't have it in me to, I'm not going to spank hard. So I spanked my child one time, and he looks at me, stops crying, he says, "That's it?" And and that was the only time I spanked my children. And it really is because I didn't have it in me to do it. It wasn't, it wasn't that he wasn't deserving of maybe something a little harder, but it was pretty amusing to me. And
Right.
he has no memory of that, but we still joke around about it once in a while.
Right. That's wonderful. That's wonderful. Yeah. So I guess we covered child abuse to I guess in a way that it will make sense.
I can probably sum that up very, very quickly. So I will. There are different levels to treating your child in a way that could be considered, probable cause for an arrest, or certainly something that would end up in independency court or something along that line, or having DCF involved. Mm-hmm. And then it starts out with neglect, and then it goes up to child abuse, and then it goes up to aggravated child abuse. And then in the very, 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 the more severe the actions, the more severe the crime, and the more severe the potential penalties. And then, of course, if it's more than that, sometimes you have children that end up with very life-altering injuries, if not death.
Mm-hmm. Right.
So it goes all the way up. I know we didn't talk about that, but you mentioned it, so I just wanted to throw that out there.
Mm-hmm. No problem. I appreciate it. So when you say aggravated child abuse, can you define that just a little bit?
In general, neglect of a child is a caregiver's failure or omission to provide child with the care, supervision, and services necessary to maintain the child's physical and mental health. Child abuse is an intentional infliction of physical or mental injury on a child, such as an intentional act that could reasonably be expected to result in a physical or mental injury, or active encouragement of any person to do the same. And then aggravated child abuse is the same, but occurs when a person willfully tortures, maliciously punishes, or willfully and unlawfully cages a child, or knowingly and willfully abuses a child, and in so doing causes great bodily harm, permanent disability, or permanent disfigurement.
Okay.
So there's the three.
Right. Okay. Yeah, I just want to make sure that we have a clear definition of that, because I know, I guess we can call it regular child abuse, which is, just you spanking your children and leaving a mark. And then you have aggravated child abuse, which is a little more severe than, I guess, what we can call regular. You know what I mean? I don't know if I'm making sense of what I'm saying.
Well, you are, but again, I don't want to confuse anybody to suggest that if they spank their child, they're committing a crime.
Mm-hmm.
I'm saying that if they spank their child, depending on the severity of it, it could be a crime. But a simple spanking traditionally is not considered here in Florida a crime. And again, maybe you have an overzealous police officer that says, "Hey, this is a crime. I'm going to arrest you for it." But a good-headed prosecutor or a good-headed judge is going to say, "No, it's not."
I see. Okay. Yeah, I appreciate that. All right, so jumping on fraud, how do you feel about that? You wanna because
it depends what kind of fraud that you're talking about.
Okay. So I want to talk about fraud when as it pertains to, let's say you go into a divorce and then you're falsifying information so that the judge will either lean more in your favor or get less from you. As far as, let's say there is a bank account somewhere, there is a mortgage that you are trying to just falsify information. So when you are standing before a judge, you are not giving the other party too much of either what you built yourself or what you have accumulated with them in a marriage.
Okay. I'm glad that you clarified that, because I thought you were going in another direction with that. I thought you were going in false accusations. So let me address your question, and then if you want to get into the false accusations later on, great. If you don't, that's fine.
Okay.
So I'll start by saying I don't do divorce work. I have done some divorce work, but it is extremely limited.
Okay.
The crazy thing, I'm not answering your question with this next comment, but handling criminal cases is so much more civilized than handling divorce cases.
Well,
Handling criminal cases is so much more civilized than handling lawsuits. It is very rare where I have a case in criminal land where all the parties get along from the perspective of the lawyers and the judge. We all can get it, but when you throw money or custody, and everything gets messy, and that gets us to where your question is, because you see it and hear about it all the time, that in these divorces that somebody is hiding something. What do you do about it? Well, again, take this with a grain of salt, because this is far from my specialty. But this is the little bit that I am aware of. There is a tool when you file for divorce here in Florida. It's standard practice to file something that limits the access to the accounts. You can't. There's an order that says you can't start messing with this money. In other words, let's say a couple has a bank account with $1 million in it. Both of them have access to that $1 million. Any one of them, before the divorce paperwork is filed, can go in there and drain the entire account. Spend $1 million and go buy a boat, or go to the casino and lose it all. You know what? That's community property. That's property of both husband and wife at that time. But once that divorce paperwork is filed, they can't do that anymore. So by filing for the divorce, you're protecting those assets first of all. And certainly consult with a divorce attorney to get the specifics on that. But I know that to be the case. As far as the fraud, let's start out on the civil side.
Okay.
Especially you see it all the time with doctors. Okay, couples getting divorced. The doctor, one is a doctor, the other one is a stay-at-home husband or a stay-at-home wife, and the doctor is a partner in this practice, in this medical practice. Somehow, coincidentally, they break from that practice. That's no longer their practice. Okay, that is the medical practice protecting their assets. They don't want, you have 10 doctors in this practice. They don't want this one divorce to be coming in and digging through all of that medical, all the finances of that. So they always end up doing that. But if they are submitting a document under oath, and they are lying in that document, that can be contempt, most likely indirect contempt. And if they commit, if they're found guilty of contempt, they can be sentenced to jail for that within the civil case. Okay, so there is a possibility of jail even in a civil case under the contempt statutes and the contempt laws. So that's what you're going to get if you commit a fraud and you're proven to. You are most times they'll say you need to fix this or else, and it's cleared up before they have to deal with any incarceration. But if they don't fix it and or they keep on doing it, there's a limit to the patience of a judge, and by all means.